corrected as you deem fit in the nature of what I consider a workshop to be, as distinct from a lecture. But you will also pardon me sometimes if I say I'm coming to that point, and so when I come to it, you can then bring back your question. But otherwise, please feel free to stop me. Can you clarify, sir, Chairman, how long do I have? I think I need, if this was a lecture, at least an hour and a half, but I can talk for 10 minutes if you wanted, and I can talk for 30 minutes. It depends on what time you have already booked, because I know this is a very time-constrained gathering with professionals. May Allah reward us all.
Well,
Assalamu alaikum.
Alaikum salam.
Jazakallah khairan for that reminder, and for the constraint is noted, and we would also adjust on our timing going forward, inshallah. But the session is meant to end by 12. It's 10 to 12, 2 hours.
Okay.
And that is inclusive of other activities as well. So we need to make allowance for question and answer. So within 1.5 hours, that will be fine if you can do that.
Sure,
inshallah.
Sure. And let me say that I am actually delighted that you have had a previous question on the same topic, and whatever I say that is correct is from the guidance, and whatever I say that is wrong is from me alone and from Shaitan. May Allah forgive us. But I'm impressed that this is the first forum that I would come to as a forum where there has been previous talk on the topic. So it should make my life easier. Today, I'm going to look at the topic mostly from the perspective of talking about what Islam says about it, rather than legal advice, which the topic seems to also suggest. Hopefully in the second part, and we have quite a number of legal practitioners here, many of whom are more hands-on on practice in Nigeria than I have been for the past over a decade. So I'm sure they'll be able to help us out on practicals, because I think that's a very important aspect too. But today I'll be looking at the question of inheritance, from first talking about ownership of property in itself that we want to inherit, then what I call the inevitable, and then the concept of will and testament in Islam, and further the rules of inheritance. Just an introduction, basic introduction to it, and then the distribution of inheritance, or the estate that is to be inherited. So first, ownership of property, or what we call al-milkiyah. In Islam, the starting point, I think, for us when we want to talk about inheriting something or property or an estate is to refer back to the original owner from an Islamic perspective. For us, this is very crucial. This is the foundation of the Islamic concept of inheritance and power to make wills, because there is a fundamental difference between the concept of ownership of property in Islam and Islamic law and other laws which we know about, like common law or any other legal system. In Islam, ownership of property belongs to Allah. Everything that is in the heavens and the earth belongs to Allah. Lahul mulk. Ma fi samawati wa ma fil ard. Everything belongs to Allah. Now, this is important because if we don't understand this, if you don't start from this point, if you don't understand this, we will have issues with the idea of how Islam prescribes for us to deal with property, to deal with the issue of inheritance, to deal with the issue of passing on things to the next generation, to family, to friends, to society, to whatever. So if we understand and accept this, then it will be quite easy for us to take on board how Islam deals with property. Okay? Allah said, Lillahi ma fi samawati wa ma fil ard. Everything. Wama bikum min ni'matin famin Allah. Whatever you have that is pleasurable, that is of value, that is good, that is, yes, the word is of value that you actually look at as something nice, famin Allah. And even what you feel is not positive, famin Allah. Allah has created everything. And that is why we need to pay attention to it when we talk about the concept of how to deal with, in the first place, Allah's property. In Hadith Qudsi, one of the Hadith Qudsi, it is stated there that Prophet ﷺ said, Allah subhanahu wa ta'ala said, Al-malu mali, wealth is mine. So wealth that we want to pass on, Allah says, Al-malu mali. The hadith goes on, but the part of it that I want to talk about is just that first part. Al-malu mali, wealth is mine. So milkiya belongs to Allah, and that immediately changes the game. This view, my house, my property, my shares, my wealth, my bank account, it's not ours. It belongs to Allah. This is very important. Why? Our role there in holding property is as vicegerent, Khalifa. That if we understand that we are ambassadors administering something that has been given to us, in this case, property, wealth, then we are immediately circumscribed. The limits of what we can do with it is necessarily circumscribed. This is important from the common law view perspective. And alhamdulillah, of course, we have common law lawyers and probably Sharia and common law lawyers in the audience and are members of H&H. The concept of, when we come to it, will in common law is fundamentally different in the way that the idea is, it is my will. It is what I will entirely. And ordinarily, you find that it is, until recently, where there has been some attempt to sometimes curtail it here in the home of the common law in the United Kingdom, people can will all their property to their cat, whether they have family or not, whether they have children or not, whether they have left a husband or a wife or not. People have willed valuable property, millions, in fact, sometimes all of their property or most of their property. There was a woman, very rich here, willed most of her property to her cat and a small percentage to a long-serving steward, okay? And you will imagine, is it the case that she doesn't come from a family? You can't do that as a Muslim. Just the case. There's no need to waste time on that. You can't. But under the concept of the idea of a will, that is essentially what it is you can do from a common law, non-Islamic perspective. So it is very important to first take that on board, that if the property is not ours, we are only custodians of it. We have only been vested with it as Khalif, as representative, as ambassador, as a vicegerent. Then you will have to conform with the wishes of the owner. So that's why we are here. Secondly, and the number seems to be growing, we are now 108 participants. Allahu Akbar. Secondly, I said I wanted to talk also about the concept of inevitability, of death. That's what I meant by the inevitable. Now, I don't think that there is a topic that we need to talk about a little more than we do now. Used to be that we don't talk enough about zakat. I think now, alhamdulillah, is changing. We are talking more about zakat. But the one topic that we don't talk enough about is the one that is inevitable. And that one that is inevitable is the one we choose not to talk about most: death. Prophet ﷺ said, Akthiruli hadimuli that. He said, constantly remember the destroyer of pleasures. Keep in constant remembrance the destroyer of pleasures, and that is death. The one thing that is certain, no matter how we plan or do not plan, is death. So we should talk more about inheritance and all of that, and become adepts at arranging for it, as we have become adepts at arranging for other things. If we take a poll of those of us on the platform, and until recently, I mean, until probably less than a year ago, I was guilty of it myself, or until maybe over a year ago, actually, I was guilty of the same thing myself, i.e., we know death is inevitable, but we do not plan about our property and the issue of inheritance, partly because of just forgetfulness, but also sometimes partly because of our cultural beliefs seeping in, which is, if you write your will, it means you want to die, or you are thinking you are going to die. By no means. As the chairman pointed out earlier, and the ayah that we all know talks about, we will die. Inna limauta alladhi tafirruna minhu fa innahu mulaqikum thumma turaduna ila alim al-ghaibi wa shahadat fa yunabbiukum bima kuntum ta'malun. The death that we all seek to run away from will meet us. In fact, it is with us. And then we'll go back to our Lord. So it is the truth that kullu nafsin dha'iqatul maut, we will all die. And there is no running from this topic. If we run from it, we are only creating a problem for ourselves. Okay? But you will be surprised. And it's an interesting thing. And I would not require them to answer. But for the lawyers on this forum, it's possible some of them have also made wills for people. But have they made wills for themselves? But you will be surprised they are not alone. One of the biggest, or one of the best lawyers that Nigeria produced, died, according to some, without leaving a will. And then later, some brought up and said he did leave a will. And the will, I don't know if they stopped the contestation on it. It was contested at least for more than a decade in Nigeria. It was contested in court. A leading lawyer, you can try and figure out who he is. And he's not alone. I wouldn't even bother you with the name, but I will leave that there. So I hope that if those of us who attended the last lecture on this topic, who were fortunate to attend it by Ustaz Jamius Trimizi, I've made your will since then. If you haven't, I hope you will. But to be honest, until I was challenged to make to give a lecture last year on it, I hadn't made my own will myself. And I felt it was hypocritical to come and deliver the lecture and not make my will. So that got me into action. And I hope it will get some of us who are remaining. I hope it's just a few of us, though I fear it is many of us, not most, that still not done or made their will. So we are going to taste death. And as a result, it is best that we understand what Islam requires from us, okay? So that we will do the needful on this. Allah subhanahu wa ta'ala has made our religion a way of life that is so comprehensive. And it's so remarkable that over 1,400 years ago, we have been fortunate to have a deen, a way of life that emphasizes documentation, appropriate documentation of legal transactions. This is one of the most important ones, which it has enjoined on us. So may Allah subhanahu wa ta'ala make it easy for us to do the needful in the proper way. So talking about wills then, so far nobody has, I'm not looking at the chat box. It's a little challenging for me to look at the chat box. So I hope the chair or the moderator is looking at the chat box, and if there's anything to bring to my attention, if you just stop me and bring it to my attention. If there's a question that needs immediate attending to, or a comment or a correction, I'm very happy to take it on board as we go along. But I see that there are some chats in the box which I don't know the contents of. So just to be sure, like I said, I'm hoping that this can be more interactive even before the question and answer session than just a lecture. But if we are happy enough to hear my croaking voice as a lecture all through, I will definitely be trying my best to meet up with that preference, as it were. Jazakumullah khair. So now this issue of the word will, al-wasiya, is what it is called in Sharia. What does it mean? Well, it's a legal declaration of how a person wishes his possessions to be disposed of after their death. You know, it is their will, what I want done. It is somebody speaking from the grave, literally. That's how it works out. Somebody speaking from the grave. And I don't know, but I hope it is the case that you don't have to actually write it. It is the case that you can record it. At least in this part of the world, it is now allowed. But maybe we can be guided by brothers who are in practice in Nigeria. They'll be able to confirm, those who know where the state of the practice is, that you can have a video as your will, you can have an audio recording. Once it can be authenticated as being from you, then it is acceptable. Probably it is even going to be more acceptable as time goes on to make audio-visual wills than written ones, since hopefully, and I'm not saying I think that is watertight, given how technology works these days and hacking and all of that, hopefully that may be more authentic than something that is written, since signatures can be forged and so on and forth. So it is the act of donating from an Islamic perspective. Now, that is the condition. Part of one's property to be given out after one's death. So this is the thing, the difference I mentioned earlier, and I won't labor the point. When you are talking about a will from an Islamic perspective, you are limited. The will part, i.e., your ability to dispose of your property, is limited, is circumscribed. It is limited to only a third maximum of your property. If you give out your property, and I'll explain a little more now. If you give out more than a third of your property in your will, the best view is that it will be reduced proportionately to not more than 1/3 of your property to be disposed of. And we'll come to understand what is at play as I go on. But this is the position, settled position in the Sharia. Making a will is prescribed in the Quran and Sunnah. But I would also make a caveat on this as we go on, because Islam is such a comprehensive and practical way of life. Alhamdulillah Rabbil Alameen. But it's prescribed in the Quran. If you look at Surah Al-Baqarah, Quran chapter 2, verse 180, Allah subhanahu wa ta'ala says, also in Shaitan Rajim, Kutiba alaykum idha hadara adakum al-maut, in taraka khayran al-wasiyatu lil-walidain wal-aqrabin bil-ma'ruf, haqqan ala al-muttaqin. Allah says it is prescribed that when death approaches any of you, Kutiba alaykum. You know this word? We hear it. Kutiba alaykum siyam. We all know that one, all of us. And I'm sure many of us know this too. But what I wanted to point out is the same word, Kutiba alaykum. You see, the one on prescription of fasting says Kutiba alaykum. The same word. So for the avoidance of doubt, it's a prescription, as salat is prescribed. Inna salata kanat alal mu'minina kitaban mawquta. Salat that is being ordered for believers is at prescribed times. So also the prescription here, we are prescribed as Muslims by the Quran to make our will. It is prescribed that when death approaches any of you, if they leave something of value, a will shall be made in favor of parents and immediate family with fairness. This is an obligation on those who are mindful of Allah. So, al-muttaqin, remember when we talk about fasting, who is it for? What is it for? It's for taqwa. Now, Allah said, for those who have taqwa, they have to understand that if they are leaving something of value, see, that is the condition. In taraka khayran al-wasiyatu lil-walidain wal-aqrabin bil-ma'ruf. Haqqan, it's a duty prescribed al-muttaqin to leave a will behind. Now, this prescription, let's examine it closer. If you look at that ayah of the Quran, Allah subhanahu wa ta'ala also talks about it. Min ba'di wasiyatin yusi biha aw dayn. In giving or in distributing the estate, Allah subhanahu wa ta'ala says in Surah An-Nisa, chapter 4, verse 11, after any bequest, that is the will part he may have made, or debt. So there are two things. There is a question of inheritance, and there is a question of a will, as our topic says. How does this differ? Okay, that is what the issue of prescription partly will explain, and also further what we mean by inheritance in Islam as distinct from the duty of making a will. Now, al-wasiyah, making a will has conditions, despite the fact that it starts with kutiba alaykum. There is a prescription for you. If you remember also, when Allah said he has made Sawm in Ramadan, he has made fasting in Ramadan compulsory, he still leaves leeway for some people who may not be able to fast. Similar here. Before this prescription applies, we need to look at what it means. So, al-wasiya, before you are required to make a will, you need to understand that for some people it is obligatory. For some people it is desirable. And yet for some people it is prohibited. Hopefully that will not surprise us, that will making can be prohibited for some people. How does that work out? What do I mean? Now, first, for people who it is prescribed for, they are those who hold financial rights of others. There is a prescription. It is compulsory so that people do not lose their property which they have kept in your trust. You have been given money, valuables. You are a manager of money, of valuables. You are a trustee of valuables. You need to make sure that you write a will to make clear to the world, to your family, to your heirs, that you do have no proprietary hold on that property, meaning that it's not your own. That issue, that house, that car, that bank account, that gold, those shares, that you are only a trustee of it. You need to write a will if you are in such a, what we call, fiduciary relationship in law, meaning that you are one who is in control of valuable things for another person. Okay, so sometimes we may see you managing or running a property, a house, and we assume as your friend and that it is yours, whereas it may be that of your wife, it may be that of an orphan, it may be that of a company, it may be that of a business that you own a part of. So you must be explicit, and you need to write a will. When I die, this is not my own. Okay, and also sometimes this is something that actually happens, that a husband and wife have bought property jointly with their names, jointly with their money, whatever. It's a joint property. We are from in the world, it is not common that we broadcast this. In this part of the world, it is commonly assumed as a starting point, unless proven otherwise, that the house which a husband and wife lives, a couple lives, belongs to both of them. Legally, belongs to both of them. It can actually in reality belong to only the husband, but it can also belong to both of them. So that is the starting point, unless there is proof otherwise. It is the other way in our system, in our culture, in Nigeria. I don't know about northern Nigeria, but I know about southern Nigeria, and I know definitely about the southwest, where I come from, that the assumption is that once there is a home, there is a property, there is a house of the married couple, typically, that it is the husband that owns it. So when he dies, the family comes in. Whereas his wife may have contributed. The land may belong to the husband, and the building is put up by the wife. But the starting point is, this is the property of our son, so we are going to distribute it. And then the wife is in a hard place. Please, if your property or part of your assets are jointly owned by you and your spouse, please do a will ASAP. Death does not write a letter to any one of us, because not only then do we leave our spouse in jeopardy or in the sadness of our loss, but also in jeopardy. And don't think it. Oh, my family is good. Oh, my family, they are Sharia people. Oh, my family, they are nice. If Allah subhanahu wa ta'ala knows otherwise, he would not say in the Quran, in Surah An-Nisa, how it is that there are problems, a lot of problems, when somebody passes. We have it in religion. Boromiro, all of those cases where you hear stories of ostracization, of pain, because the person concerned had not left a will. It is the case that some of us would actually also have been negatively affected if we are not lucky to have parents who had written a will. Howbeit that will may or may not even have conformed to a perfect Islamic understanding of will making. So it is very important when we think about this issue of financial rights of others, that we are not thinking only of, oh, I don't have any friend that has given me anything. You must also think that, or remember, for instance, that it is common, very common, that the husband builds the house. Yes, he bought the land, he built the house. But there are things in the home that the wife provided or bought with her own money. It is common that a working woman would make herself happy in her kitchen. Yes, you may have bought the fridge, but she may decide to buy a freezer. You may have bought a cooker. She may decide to buy a fryer. But you may have bought I don't know, you may have built the cupboard. She may decide to buy her own set of cutleries that she prefers and plates and all of those things. But when the husband dies, the family comes and sends the woman out of the house before you know it, sends the children out, and all of those things, and all of the agony and sorrow that we face, especially, and it's ironic, especially in Muslim families, and especially with us having sometimes polygamous unions. Even the monogamous one is made little or no difference at all. So this is a very practical issue when it talks about the financial rights of others. So the woman is already in mourning, but she is also being deprived of her property, and nobody's going to believe her. Is it not the money that my brother gave you that you used to buy it? At best is what she will be told, if at all that it is even accepted that she bought it for herself. So this is, for such, it is going to be difficult to think about anybody on this platform, except maybe an unmarried or young person. And I don't know the demography of those of us on the program. It keeps growing now, 132, that this issue of having financial rights of others does not apply to. So please, let's think about it. Prophet ﷺ said, it is not permissible for any Muslim who has something to will to stay for 2 nights without having his last will and testament written and kept ready with him. So I want to use this to just make the point clear here. It is likely that if you are you have even average means, that you will have something to will. The meaning of having something to will here should not be misunderstood to me. I'm not a billionaire. That is not the meaning. The meaning includes the first one that you are thinking about, oh, something that I own that I would like to give out in a particular way. But it extends beyond that. It extends to that not everything that is being seen as yours, that is actually yours. And you're not going to put an advert, this car is for my wife, or I bought it and given it to my wife. It is that you and your wife know, but maybe you've not perfected the documents. And even if I perfected the documents, is useful knowing the problems that have emanated in the past from our community and our society to put those things clear for the avoidance of doubt in a will. Yes, making a will is desirable in certain circumstances. And if you are not in the first group, then you are likely, most of us on this platform, and far more people than we think, will also still fall into the category of making a will as a desirable thing under the Sharia as Muslims. Okay? So once you have anything that is of value, it is best that you write a will, especially if, for instance, your hair is well off. If your hair or your hairs are well off, Okay, if your heirs are Dangote and $10 and whatever, Bill Gates, then it is very desirable that you make a will so that you are able to benefit others. Okay, Allah subhanahu wa ta'ala has made it such that you could have, in your case, heirs that did not even need the property that you have, either because they are better off or they are equally okay. We are encouraged in the ahadith compiled by Ibn Majah, Imam Bayaki, and Darakutni to still make a will. The hadith goes that Allah subhanahu wa ta'ala made a charity upon you at death, allowing you to give 1/3 of your wealth as charity to increase your good deeds. To increase your good deeds. So for such people, they will still require to make a will. But there are people who it is not desirable to make a will. And this is found in the Sahih Hadith of Imams Muslim, Bukhari and Muslim, where Prophet Sallallahu Alaihi Wasallam said to Sa'ad bin Abi Waqqas, radiallahu anhu, you should leave your inheritors wealthy rather than leaving them poor, begging others. Because Sa'ad bin Abi Waqqas, radiallahu anhu, he came to the Prophet Sallallahu Alaihi Wasallam. He said, I want to give most of my property away. Then he said, Prophet said, no, don't do that. He said, okay, half. Prophet said, half is still a lot. And he went on until Prophet ﷺ said to him, look, that you should leave your inheritors wealthy rather than leaving them poor is better. So sometimes it is not desirable if you are not leaving much to actually write a will. It's undesirable to. We don't even have much. So it's better that your own heirs, and I'm going to come to this point again soon, are left in a strong position, because despite sometimes the understanding that Islam wants us to not value wealth for its in the way that the non-Muslims value it. Yes, it's not a misunderstanding, but despite the tendency to misunderstand the place of wealth in our lives and to characterize it as something bad, Islam is a religion of pragmatism. It does not it's to kufr. Prophet used to say, Allahumma inni a'udhu bika min al-kufr wal-faqr. Oh Allah, I seek refuge with you from disbelief and faqr and poverty. You call in al-faqr mal kufr. So Prophet is bringing together kufr and poverty, because one can lead to the other. So Islam makes it undesirable if you're not having much for you to now say, oh, I'm still going to give out up to 1/3 of my wealth. It's undesirable. Ali radiallahu anhu said to a man, you have left only little property, so let it go to your heirs. When the man was proposing to actually give out some of his property. Okay, we find this in the hadith of Imam Ad-Darmi and in the book of Ibn Abu Shuayba. Now, that is about being undesirable. There is actually a category of people or circumstance where making a will is outrightly prohibited. So we've looked at prescribed, where you must, that is when you have the property of others in your custody, you must. It is desirable if you have some wealth to give out, still make a will. It is undesirable if you are not living much, even though it's not prohibited. But it is outrightly prohibited if the intention is to deprive some of your heirs from getting a share or a good share of your property. Those children, I'm very cross with them. That my wife, that my husband. Oh, by the way, I hope sisters are on this program. Can that be confirmed, please? Chair, moderator, are there sisters on the program? Hello? Are there sisters on the program, please?
I doubt it.
No, there will be sisters.
There are sisters.
I think there are.
There are sisters.
There are sisters.
They are already answering you. They are already
okay.
telling chat that they are here. And we can see names like Farida, Zaina, Fatima.
Okay,
so.
Alhamdulillah. Because what I find intriguing about H&H is that I suppose there is also an H&H for sisters. I don't know how it is, but I hope there's an H&H for sisters too. But the point I wanted to make is that when we talk about wills, and I hope I'd implied that, but I need to make it explicit. It's very, very important. When we talk about wills and all of that and property, there is a tendency for us to think about men only. Please, let me make myself clear that wills as a prescription is for men as well as women. The notion that no applies to. So I just wanted to, just occurred to me that since I'm in a forum where most of us, or the organizers, are all male, it is important to remind us. So please, this is not about your husband making his will. It is also about your wife, sisters, making their will. So husbands, make sure that this is not a one-sided thing when you are talking about it. Now, what reminded me was the issue of heirs. Okay, so it is prohibited if the intention is to reduce the property through giving out 1/3 of it to ensure that you are able to use it to punish the heirs to the property. Now, the reason why this has to be clear is that when we talk about, like I said, in Islam, you are only allowed to give out 1/3 of your property. There is the concept of will making as well as inheritance. And even though they sound to be the same thing, well, there is a little difference here. The difference is that your will is over 1/3 of your property. The 2/3 is compulsorily not a favor. It's a right of your heirs, whoever they are. Okay. Now, Prophet Sallallahu Alaihi Wasallam said on this issue of how it is prohibited to deal wrongly in a will and the nature of it as a grave sin. He said it could happen that a man spends 60 years in obedience to Allah, and when he's on his deathbed, he may cause harm to his heirs in his will. So the hellfire becomes inevitable to him. May Allah save us from that. You find that in the hadith Sunan of Abu Dawud and Imam Tirmizi, as well as Imam Ibn Majah. Ibn Abbas radiallahu anhu also said clearly that causing harm by the will is one of the kaba'ir, one of the major sins. We find this in the hadith books of Imam Ad-Daraqutni and Imam Bayhaqi. So there is no doubt that it is prohibited to make a will in order to try to dissipate part of the property as a punishment. The intention is key here for those who are going to benefit as your heirs, because you have an obligation to your heirs when you are making a will. For your will to be valid, and I'm not talking from the common law perspective here, so pardon me, my common law experts. The will, but still, you'll be surprised that when it comes to issues like this, most of the elements of the common law, with the exception I've noted, share a lot of principles with Islamic law. The common law shares a lot of its basic principles with Islamic law. And I know that that is not something that is very clear to many of us. I'm not justifying the common law, but I know that it has its roots in canon law, partly, but I have actually seen research that shows that a good deal of the elements of the common law were direct transpositions from Islamic law when Islam came to Europe through the Mediterranean and onto what is now Italy, and then to England, as it were. But that is a story for another day. The principal issues here are regarding validity of a will, like I just wanted to mention, shares elements with common law. It takes effect after death. That is the same with the common law. A will of up to 1/3 of property is allowed. I've said that. That is not in tandem with common law. A will cannot be made for a heir. That is also not in tandem with common law. You can include and exclude anyone you want. But in the common law, you cannot, with exceptions, and also in the common law too. The court can actually refuse some parts of the will and declare it illegal, at least as practiced now in the United Kingdom. I don't know what the position is in Nigeria, but in Sharia, a will cannot be made for a heir. So what does this mean? This is very important. You cannot look at people who are entitled to inherit you, say for instance a woman, her husband, say for a husband, the wife. You cannot then pick, you are a husband, you cannot pick your favorite wife and give her more in your will. You cannot pick your favorite son and give him more. You cannot pick your favorite daughter and give her more. No, you cannot. Or your favorite brother or your favorite sister, as the case may be. All bequests take effect only after obligations. So what does this mean? So when a person dies, there is a way that the Sharia wants us to deal with the property. And I think that itself is a separate deal with the assets of the person. That is a small separate discussion, but the part of it that is important and relevant to will making here and to inheritance here is that all bequests take effect only after obligations. You cannot inherit whatever there is there when the person's debts have not been paid. So one of the first things is when a person dies, contrary to common practice, we are supposed to take the person, unless the person is penurious, we are supposed to take the person's from the person's own property to bury them. It's not for people it's not for people to need to contribute for the person's burial. Ideally, unless the person has no wealth, it is from the person's wealth that they should be buried. When that has been dealt with, then the debts that the person owes has to be paid. It is only after that, and also before the inheritors take their portion, the will part then comes in, the bequest. I want to give 10,000 or 10 million to H&H or H&H school. I don't know if that's the name of the school that H&H runs. May Allah reward you. I want to give 1 million to Ansarullah or to Ansaruddin. I want to give 5,000 to Unilag. All of those things you can do, but they take effect only after the person has been buried, the funeral expenses have been met, and then rather after the funeral expenses have been met and after the obligations, including debt, has been paid, that you can then share out the the estate, first the will, and then the inheritance. Now, what do I mean when I talk about inheritance in Islam? Simply, it is the shares, fixed shares that are allotted to legal heirs by the noble Quran in the estate of a deceased. Now, when I say that fixed shares is actually an overstatement in a particular way, there are only a fixed number of categories of people that have fixed shares in the Quran. And we'll look a bit at this. I'm not sure that is today, but we'll see. Only a fixed number of people. The others' shares will then fall into place, so to say, and then adjustments will be made. It's a very interesting scenario depending on individual particular circumstances. So it's not likely that you find two people whose property can be shared in the same way. That is in terms of the inheritance. So I've left the issue of the will now. In terms of the inheritance, after the will has been dealt with, you use the will. Yes, I should say this also. You use the will for other purposes. So you use the will to set out your property, your assets, those assets that may be entrusted to you, those liabilities that you have. Yes, the debts you are owing or liability that you have. I'm owing my wife 5 million naira. Or the land in Oshogbo actually belongs to my wife. And so on and forth. You set out your liabilities, your assets. Some of those things are not known. This is one of the most important things about writing a will. We sometimes deal in acquiring property quite understandably, secretively. And when the person dies, some of those properties will be lost forever. It will never come to the family because we have not documented it in our will so that people will know that we have such. So that is part of the uses of a will generally, whether it's in common law or from an Islamic perspective, but it is very important to just make a note of that, that one of the most important reasons to write a will is to document all of our assets, all of them, whether it's a bank account number, whether it is a house, whether it's shares in whatever company, or whether it's savings, whatever it is, whether it's gold, whatever it is, whether it's a house, we need to use the will to document that. But that is so much about the will. But we must understand what is to be shared hopefully should flow from the text of the will itself. Even if you're not giving out anything, documenting it, and then documenting who your heirs are. Now, that may be a little tricky because if you don't understand who your possible heirs are, the most basic you think about are your nuclear family. Well, it's not just your nuclear family that could be your heirs, but it is relevant at least to mention those, but to understand that from an Islamic perspective, depending on your family structure, you may, your brother, your sister may also be part of your heirs, and they may not be. But it is also interesting to point out, as we will see, that unlike the way we think about wills in the common law system typically and culturally, in living property, we shy away from a reality, which is important to point out here. And that reality is that we think about wills as something that goes down. I mean, something that goes down or sideways, something that goes down in terms of from fathers and mothers to their children, or to brothers and sisters, hopefully who are younger than us. But that is not the Islamic conception of it. We need to understand that whether we mention them or not, actually, just like children are able to inherit from their parents are able to inherit children too. I know culturally and emotionally as people and society will say, God forbid, yes. But it would be strange to find on this platform of 145 adults right now, and I'm sure there are more people than 145 because we are sitting in families, that somebody has not inherited a child. How do you inherit a child? A child that has died when they were born, you inherited them, they've died, whether they have an asset or not, whether they have a liability or not, you inherit them. And that's the other thing I wanted to talk about briefly when you talk about wills. When we talk about wills, we typically think of who we're going to get. But when we talk about inheritance, we should also understand that the heirs that can inherit are not able to inherit just assets. They are also required to inherit liabilities. So that is very important to also talk about there. Now, I also want to just say something basic about the study of the rules of inheritance. From what I've just said, we begin to get an idea that this is a potentially complex area. And it is why the study of estate division and their juristic rulings and calculations for distributing shares is, by the agreement of most scholars, the most challenging aspect of Sharia. This is the area that studies the rules of inheritance, and it will require knowledge of sometimes some at least basic mathematics alongside understanding of the Islamic prescription. This is an area that I hope professionals like us will take an interest in, given that we have financial experts. We are supposed to have law firms, solicitors who will specialize in that to make it quite easy for us to practice what Islam envisages on rules of inheritance. Prophet Sallallahu Alaihi Wasallam actually enjoined us to do this. He said, learn the rules of inheritance and teach them to others, for they are half of the knowledge. That is knowledge of Islam, and they are liable to be forgotten. Besides, they are the first branch of knowledge to be taken away from my nation, Ibn Majah. And I make the confession myself that I'm not an expert in the mathematical calculation of inheritance in Islam. I can only talk about the basic prescriptions, but beyond that, we will need people to actually understand that there are statistical, mathematical calculations that will be required to ensure that the property is properly distributed, as it were, when it's time to follow on this as we all pass on. May Allah subhanahu wa ta'ala make it easy for us. Now, it is then opposite to move to the rules of inheritance itself. What do we mean by them? Okay, I'll just introduce us to the basics of them, which basics are applicable as standard. This is not about calculations, but basic rules and principles guiding inheritance in Islam. And the first is that when a Muslim dies, 5 obligations are deducted from their estate. I've mentioned this in passing, but this is the way it works. In this order, the first is the funeral expenses, as I said. The second is the payment of the debts that the person owes, the debts to Allah, then to people. So you may wonder, what's the debt to Allah? Well, the prime example is Hajj. If somebody has died and they have left substantial property, then it is highly recommended, at the least, that if the person has not performed Hajj, that we take of their property, get someone to go and perform Hajj on their behalf. This is a debt they owe Allah. If their property is due for zakah and they have not paid it, at that time they die, that is a debt owed to Allah. The zakat must be extracted and must be paid. If they had made a promise to someone, I will give you so on so date, and they die, that is a debt, because Allah will ask about it. Then it should be paid also. Then the next one, so that's a debt to people, it should be paid. So the third one is bequest, which we've talked about, the will. I want to give this out, what we typically think about when we talk about wills, but with the caveat that what you are giving out is not to anybody that can inherit you. And let me just slip this in here. It is remarkable that people say, oh, Islam is a harsh religion or this because of ignorance. Now, Islam forbids zina, and may Allah save us and protect us from zina. And it says that the child of zina cannot inherit from the parent, but the parent can actually provide for a child of zina in their will, just that as they can provide for any other person or for others, because that child is not their heir. That is typically the man. That child is not their heir, but they can provide for the child in their will. And I'm not saying that people should go out there and commit zina, but it is just worth noting how Islam is a religion of tasamuh. It's a religion that has such a compassionate view to human beings, that our major challenge is knowing, understanding, then applying. May Allah make all three easy for us. The fourth one then is the distribution of whatever is left to the heirs of the person. And that is where ilm faraid comes in. If there is left over, then distribution of remainders to relatives who are not heirs. Those relatives that are not heirs, as it were. There's always some problem when we have to move from Arabic to English. But if we are using the Arabic terminology, it will be clear how we can talk about relatives who are not heirs. And when I say relatives, I don't just mean that heirs are the typical limited way that we think about them. Your son, your daughter, your wife, your husband. No. So Islam has a definite a definition of its own for the concept of heirs, but we have so much limited time, we can't go to every aspect of the issue. Now, part of the rules, then, that is the first one I've said. The second rule is prohibition of changing the law of inheritance. We cannot change the law of inheritance because some people view it as being not modern. Okay? Allah subhanahu wa ta'ala said, Tilka hududullah. The laws of inheritance that he has set out, after setting it out, he said, these are the limits of Allah. He has drawn the border on this issue. Whoever follows the injunctions of Allah and his prophet, he would enter them into Al-Jannah, under which rivers flow. Khalidina fiha, and they will stay there forever, eternally. This is the greatest achievement. But whoever disobeys Allah and goes on to change these rules of inheritance, and goes on, yes, to change the rules of inheritance by going outside of the limits that he has prescribed, Allah will enter him into hellfire. So not abiding by the rules of inheritance is one of the kaba'ir that leads to hellfire. May Allah save us from it. Allah specifically said this. Khalidan fiha. Allah said they will stay abiding it forever. So it's not a light issue at all. And it's easy for us to understand where this is coming from. from where I started. I said, the matter is taken from our hands in a very radical way. What matter? The ownership of the property. It's Allah's. He says, I own this property. You must administer it the way I want when you are alive, and you must leave it and pass it on when you are dead in the way that I want. So there is no issue here. If we agree that Allah is the owner, then we have no problem in dealing with the property whilst we are alive and when we are gone, in the way that Allah subhanahu wa ta'ala wants it. But he uses the word, he would enter fire khalidan fiha walau azabun muhin, and then there will be degrading punishment for the person because it's an act of arrogance. And that's why it's a degrading punishment that the person will have. And I pray that Allah subhanahu wa ta'ala save all of us on the platform today, those who are not here, who are all believers, from the degrading punishment in the hereafter. So that is in Quran, Surah Al-Nisa, chapter 4, verse 13 to 14. Still, one of the rules of inheritance is this issue of the causes of inheritance. How do you become somebody who is a heir of another? The first one is blood relationship. That's very common. Your children, your parents. That is very common. Your siblings. You all share the same blood. So your children, your parents, and your siblings. That is the blood relationship, for instance. The second and the other part will be your uncles and all of that, and your aunties, of course. The second part, the second cause of inheritance is marriage. You are married, you have a husband, your husband inherits from you. You have a wife, your wife inherits from you. Okay, that is the marriage relationship. Al-wala, and the relationship of slave and master, and a master-slave, emancipated slave relationship. But that today is not something we are going into because it basically just has fizzled out in common practice. So we are concerned essentially with blood relationship and marriage. The rules of inheritance, yes. So now the heirs, to make it clearer, the heirs who inherit due to relations at 3 levels. And the first level is the father and the mother. I said it earlier. When we think about wills and inheritance, we think down. But no, it's Allah's design that unfortunately some people are going to predecease, their children will predecease them. The Prophet ﷺ predeceased all of his children except one, Fatima radiallahu anha. So we pray to Allah to have our children and us live long, and for them to inherit us, and for us to inherit our parents, for those of us whose parents are still alive, and may they live long in good health and in guidance, and all of us. But the reality is, Islam recognizes that some parents will predecease their children will predecease their parents. So on that first level, there is the father and mother, the children or descendants of the children, where the children have also, or a child has died, the descendant of that child. Okay. Once there is one from the first level, there is no inheritance from the second level. Once there is somebody from the first level, there is no inheritance at the second level. This I will repeat. So this is a level. Father and mother and children, they are a level. Okay. Once any of these people are alive, the second level we are going to, they don't inherit. Ordinarily, they don't. You may give them if this group of people allow, but ordinarily, once somebody dies and has a father, a mother, or a mother, or children, then ordinarily the next level doesn't they are blocked. The next level doesn't come into feature. So the second level here is the grandfather and grandmother. So in the presence of parents, the grandparents do not inherit their grandchild. Brothers and sisters and their children in their absence. So if the person that has died has children, then their brothers and their sisters ordinarily will not be able to inherit. When there is an individual from this second level, there is no inheritance from the third level. So what is the third level? The third level is the level of paternal uncles and paternal aunts, and maternal uncles and maternal aunts, and their own children if they have died. So the first level, it will end there if they are present. If they are not, we go to the second level, it will end there if they are present. If they are not, it goes to the third level, as it were. So this leads us to saying a bit more about what is involved here with this leveling. It is about the concept of al-hajab. You know the word hijab? Al-hajab, blocking, as it were. That's what it is, preventing someone from receiving from the inheritance is al-hajab, or from receiving some or all of the inheritance. There are two types of hajab. We call one of blocking. There's one that is hajab or nox, and the other one is hajab al-absat. Now, hajab or nox happens when a heir is moved from receiving a larger to a smaller share. They still get some share, but it is reduced. What can lead to that? What can lead to it is the presence of many different types of legal heirs can lead to a reduction in a prescribed share of a heir, or when there is a change from one state to another due to the existence of other heirs. Like I said, this can be complicated, but I thought it's worth mentioning that there is a concept of blocking, where when certain conditions are met, you either don't get at all or you get a reduced share. That is basically what we need to pick up from there. We don't need to disturb our heads too much about it, about technical details. But a quick word about the other kind of blocking, hajabul iksat. That is complete blocking of inheritance. This will happen due to existence of a person that is more entitled to the inheritance. So the person may be a heir or ordinarily, but where there is somebody that is more qualified because they are closer to the person that has left the estate, then they get to completely block out, shade out another heir, because we have a concept of primary heirs that are always entitled. These primary heirs will be the spouse, so the husband if the wife is dead, the wife if the husband is dead, both parents, they are always entitled if they are alive and their child has died. The sons and daughter or sons and daughters are always entitled if the person has left children. So these are primary heirs. Secondary heirs, as for secondary heirs, all others can be totally blocked by the presence of other heirs, as it were. So even though it moves to secondary heirs, there is also a category of primacy among them, depending on how close they are to, by blood, that is, to the person that has died. So there are several rules about these issues of blocking, but let's look at the example. First rule is related to the deceased is that whoever is related to the deceased through a certain person is blocked by that person. So let me take that again. Where there is a person related to the deceased through another person, that other person blocks this relation. How do I mean? So a son of the deceased blocks all grandsons, and the father of this deceased blocks all his own siblings, as it were. So it can be downwards, it can be sideways. So where a father is there, and you find out that sometimes, even in our customary practices, we have an idea of this. It is said in other times we violate it because of the fact that we are not using the Islamic standard. And that's why it's very crucial that we understand it as individuals, to not only use it for ourselves, but to actually help out in our larger families as Muslims. So that is an example, that a son blocks his own sons and a father blocks his own brothers because he is present, or a mother blocks his own siblings, as it were. The second rule that we can also talk about is the rule of agnacy. Agnate heirs take priority based on degree of proximity. Can anybody tell us, since I've been the only one talking for so long, what agnate means? I'm sure people will be able to tell us. There are lawyers here and even non-lawyers. What's the meaning of agnate? So that if there are one or two people who don't know, we'll be able to clarify and everybody will be on the same page. What's the agnate? Who is an agnate? Anybody, please. It's a workshop, but I'm not going to leave it like this. If nobody tells us, I think we will have to find everybody. I'll just send my account number. I don't want to, but we need somebody to tell us the meaning of agnate. Anybody, please. I don't want to call names, so, and I exclude Ustaz Harun. I exclude Ustaz Harun. That leaves 147 of us. Yes?
So, Prof, I think based on my own understanding, it's people from the same father.
People from the same father. Anybody has a contrary idea? Jazakumullah khairan. Who is that brother? Please, I can't see because of the configuration. Huh?
My name is Taufik Babalola.
Brother Taufik Babalola, Jazakumullah khairan. Thank you so much for bailing us out. But maybe he's wrong. Anybody else? If you believe he's right, even still, say so. I support that definition. Anybody? It's only Brother Taufik, please. The answer is Brother Taufik is, of course, right. If you look at the third slide, maybe that's why nobody's, because we all agree. I already sort of hinted at it. Full blood excludes half blood true father. Okay, but an individual closer to the deceased excludes one in the same class who is remoter. Full blood excludes half blood true father. So the concept is to make sure that the person who is being inherited actually is inherited by those who are closest in the first instance by blood than otherwise. I think I have exhausted my time. If I understood correctly the sort of time configuration we have for the delivery of the lecture part of the workshop, and we can now open up for questions and answers. There is a lot I still like to talk about. Wa alaikum salam, but I don't see myself being able to do it today, as I said earlier.
Jazakallah khairan, sir. Thank you so much. Jazakallah khairan. It's already, yeah, it's 12. It's past 12, some minutes after 12. And that time has been exhausted, except the audience says we continue. But we have a few questions in house. And also to mention, people were actually responding to your question, but they were muted. No, so there were a few responses to your question earlier, but people were muted, so they couldn't speak.
I'm sorry.
Apologies on Agnate. So people were responding actually.
Jazakallah khair.
So I don't know. Can I read a few? We have a few questions from the chat room.
Please.
Maybe we can start from there.
Yes, please. I'm sorry that I'm still a bit confused because it's 1 hour behind your time in Nigeria. So I was so happy that it seems I've spoken for only 30 minutes or something. It's 11:09 here. I'm sorry.
No, it's okay. We should thank you actually. Yeah, the first question says is from one of our, okay, we have the question that says, it speaks to my, okay, says, Assalamu alaikum. I've listened to some school of thought that says writing down of will and testament in any form is unknown to Islam. Disposition of property has already been taken care of in the Quran. Can you please clarify this position? That is from Ajibola Oduwole, Esquire.
Thank you. Do you want me to immediately answer that? I can make it very brief. I think.
Yeah, please answer.
Yes,
I will take the question one by one. Please answer.
That's the best. That is a very strange proposition from whoever has said so. I think what they mean, because of the last part of the question, I think there is no issue of writing down is prohibited. In fact, it is the opposite. With the hadith and even the tafsir of the Quran on what we have gone through today earlier on, it is actually the case. It's like suggesting that we shouldn't write down mortgage or financial transactions in Islam. Islam is one of the religions that emphasize, just like the Arabs said, that whatever you don't write down, you tend to forget. I think what is being mixed up in whoever was saying what the Prophet brother heard, Allahu Alam, or read, what is being mixed up there is the idea of mixing inheritance with wasoya. That is the thing as a limited concept. The will part, like I said, yes, we don't specify the shares of those who are heirs, but where do you put the right of the person to dispose of up to 1/3 of their property? That has to be documented. That has to be written down. That is one. Two, how do we even know their property that the Quran has prescribed should be shared? Yes, how do we know it? And three, when it is said, anyway, and this is not even for arguments, this is just as an aside, when he said that the Quran has set out the rules, it will be very interesting to know that those rules are going to be used in a specific context, and you will find situations that means that they have to be reduced, they have to be adjusted, and it is not especially written in the Quran like that, that they then reduce it to this or then reduce it to that. No, what is written in the Quran is the basic principle of what is to be shared, and we are going to still talk a little bit about that. For every male, they get double the share of a female, for instance. And then Allah subhanahu wa ta'ala talks about the parents and gives them a definite share. And he talks about the husband and gives the husband a definite share. But all of these have to still be calculated. That is in terms of distribution. I'm not even bothered about that. The person is right in principle, whoever was saying that, but the shares have been, allotments have been made in the Quran. But how do you take care of debts? The concept of wasoya in Islam means that you have the rights of people which you need to document so that they don't lose their rights. You have people who need to be mentioned, that you have assets which need to be mentioned so that it is not lost to your heirs. because you'll be doing them an injustice by not letting them come into assets that that's meant to be passed on to them. So it's a misunderstanding of what the position is to suggest that it is not to be documented. Whether that documentation is to be written or is to be done by video or whatever, Islam firmly, by the text and understanding of the Quran and the Sunnah, wants us to actually write it. Prophet ﷺ said it in the hadith. So I don't know where any suggestion that we cannot write a will in the limited understanding of what a will is supposed to do, as I try to outline, is prohibited in Islam. It's not at all. It's not, and it's not a bid'ah.
No, Jazakallah khairan, Ustaz. The next question is, if someone leaves a will that his property be shared in accordance with the dictates of Islam, but some of the beneficiaries dispute that this property should be shared in accordance with the common law principles, does the Islamic law pass the repugnancy test? This is from Mansour Bashir.
Very good. In fact, Mansour Bashir, Jazakallah khairan, and the moderator, I'm so pleased that you are placing that question as the second one immediately after the first one, because it sort of occurred to me that I wanted to talk about this, what this question is asking, as an addendum to my response to the first question. Namely that in Nigeria, and I suspect there may be some other people outside in diaspora listening on, and whether it is in Nigeria, we can still manage things a bit, but we see already that—
Why are you using at him? If you use at him today again, I'll be.
So in Nigeria, we already see there are problems, but for the avoidance of doubt, if you don't write your will, I wanted to add that if you don't write your will specifically, especially, definitely in Nigeria is problematic enough, but it is even a big problem for you if you are in diaspora and you don't write your will, because the laws of the country you are in will have dominance, will take over your personal law, your personal rights, as it were, to your detriment in two ways. One, with Allah, in terms of your property will now be shared with a law, under a law that is not under the Sharia, that is not in accordance with the Sharia. So you are doing harm. Secondly, that it is actually also going to be the case that you will lose, in most of the Western countries, you will lose a substantial part, you stand to lose a substantial part of your property, especially if you are middle, upper class, and not to talk about being upper class. You will lose a substantial part of your property to the state. So there isn't, even for your own selfish reasons, you must do a will anyway. And as a Muslim, of course, make sure it is in accordance with Islam. So that is if you are in diaspora. And if you're in Nigeria, we all see all the troubles that goes on. To answer the last part of the question of what is it called? Repugnancy and all of that. Well, first, for the avoidance of doubts. When people say Sharia does not apply in Nigeria, we don't want Sharia, all of those is a redundant talk. When people say we want to introduce Sharia into Nigeria, it's also redundant talk sometimes. What do I mean? I know that can be strange and shocking to us. Sharia is part. I'm a barrister and solicitor of the Supreme Court of Nigeria, called to Nigeria by over 20 years, 22 years ago. I'm sure there are people here who will have that kind of legal standing, if not even higher. They will all testify to it, that in the Nigerian constitution, the one sure part of the Sharia that is recognized is called personal laws. That is in Nigerian law. The question of repugnancy, no repugnancy, does not apply at all. When it comes to personal law, it does not, because it is recognized. Customary law, Nigerian customary law, Benin customary law, Yoruba customary law. If there is a customary law in any other, as there are in any other community in Nigeria, it is recognized in the Nigerian law in the Nigerian constitution. So there isn't question of repugnancy is my direct answer to that. But even more to reinforce it, at the level of the Court of Appeal, which is a federal court in Nigeria, there is a constitutional requirement that you must appoint some people to it who have not just common law knowledge, but Sharia law knowledge in order to take care of the Sharia jurisdiction regarding at least personal law. This is going to the Supreme Court all the while. And to crown it, in the Supreme Court, there is a specific number, I think three judges of the maximum 21 must be appointed, apart from being qualified as legal practitioners in Nigeria with at least 15 years experience post-call. They must have knowledge of Sharia law. It is in Nigerian constitution. It has not been changed since 1979. So there isn't a question of repugnancy at all. No question of repugnancy. That's my answer to that, because it's what we call personal law. And personal law can be customary law, Islamic law, whatever. And it is recognized in Nigeria. So from a legal point of view, there isn't a question of repugnancy at all. There isn't.
No.
But Nigerian law, there isn't. And to crown it, here, in the UK, for instance, or in any standard Western country, there isn't a question of repugnancy if you have made your will, because you see, this is how the law in the common law system works to reinforce your ability to use the Sharia, and why we must make our will, especially for those of us who are in diaspora, definitely for those of us in Nigeria too, is that it is your will after all. The common law principle is you can dispose of your property any way you want. You just need to prove that you are sane, this is specifically what you intended, and this is the property which you intend. That is why we need to write it there. And there is some discussion as to the extent you need to make it clear or not. Maybe it is Maliki or Shafi. That's it. That's hair splitting. The thing is, the High Court of England will enforce your will. That is an Islamic law. That's under Islamic law. That is stated.
No.
It will. So there's no.
No. Jazakallah khairan, sir. Thank you so much for that detailed response. May Allah increase in knowledge. And the next question is from Ibrahim Alabi. Can someone share his assets to his due heirs while still alive just because he's very old or has terminal illness?
I will leave Ustaz Harun. I will crave his indulgence to correct me on this. It's not because I feel he's the only one that can correct me, but at least I know him here. I don't know the other learned people on Sharia law that I'm sure I hear. But two issues have been mixed here in that question. I would like to be clear on one, and the other one, I would like to be corrected if I'm wrong. The idea, there is an idea here, and it's actually something I would wish to talk about in the second part, if Allah allows us, but we don't know. So let us just treat it. And there's a question on it. You can gift most of your property while you are alive. You can gift most of your property while you are alive, including to your heirs. And that is not a will. There will still be things left that they can inherit if you, definitely. But it's an idea that we have to think about. You can gift most of your property, and there are some benefits to it. You are sure what is going to who gets to them. But there are rules for gifting in Sharia when it is your property of this nature. Somebody came to the Prophet ﷺ and he had said, I have given part of my property to this, my son, or something. The Prophet said, did you give the others? He said, no. He said, you have to give them equal shares. Now, the thing about gift is that it's different from the rule of inheritance. If you have daughters and sons, inheritance, they have to inherit you under the rules of Sharia that the son will take double of what a daughter will take. But when you are giving gifts as children, my understanding, as gifts, you are given as gifts, not in your will, which you can't, to your heirs. If you are given as gifts when you are alive, you can give, you should give them equal shares. Now, as to the person that is old and ill and they feel they are dying, as long as they have mental capacity, my understanding is they can still give. Allah. Because in fact, Allah actually references when you are on your deathbed. Yeah. But if I'm wrong, that because they are ill and are dying, they cannot gift, please, my Sheikh, Ustaz Harun, please correct me on this. Or if you can contribute to the answer, I will be obliged.
Now, while we are expecting Ustaz Harun to make contributions to that, let me also make another question that is related. If a member of...
Excuse me, Imam Ahmad is raising up his hand. He might be to address what the guest lecturer just talked about. I think we should please indulge him.
No,
I didn't know Sheikh was there. Salamu alaikum. Please, Sheikh.
Alaykum salam wa rahmatullahi wa barakatuh. Thank you very much. Jazakallah khairan.
Amin. Amin.
Well, I had put up my hand for a while now before the last intervention. You know, those of us who are lay people, unlike our Sheikh, because we lead prayers in, you know, backstreet mosques, a lot of cases are referred to us that has to do with inheritance. And one of the constant questions is the question relating to will. It is very, very constant. And what I have discovered over the years is people lack what I will refer to as wasiya intelligence. I think we need to always make distinction between wasiya in the Sharia and will in the common law. The general understanding of the people is that it could be used interchangeably, and that will lead to a lot of confusion later. So I wanted the Sheikh to clarify for the benefit of those who are listening who may not properly understand the difference between wasiya in Islamic law and will under the common law. Further to that, my just very brief comment on you know, gift and will, and as to whether someone could gift his properties while alive. Well, the Sheikh has responded, except that I would like to add, it must be for very clear intention. It must not be to disinherit particular heirs. And like he has said, I agree, and I want to emphasize that there's a different rule under the Sharia for gifts as it relates to those who could inherit. Gift to heirs must be equal. It must be fair to all. And he has referred to the hadith of the man who wanted the Prophet to be a witness to a gift that he has given to one of his children to the exclusion of others. And the Prophet was very vehement that he will not be a witness to what is haram. Again, you know, there is a bit of a gray area between gifts on deathbed, even while still, you know, the person still has hold of his mental capability, and gift at other times. These are also areas that I like to the Sheikh to clarify. There could be live instances where someone is sick on his deathbed, and a particular child is there taking care of him, and he decides to give that child a gift. Under the Islamic law, would this be acceptable? Would this be valid? Can it be upheld? These are also areas that we need to clarify. Jazakumullahu khairan. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Let me first say, if you permit me, moderator, do you permit me to respond to Sheikh?
Of course, yes. Please go
ahead. I am deeply honored that Sheikh Ahmad is found time to be on this, to listen to a student like me. Yes, Sheikh Ahmad, I know you, and we've met in person way back decades ago when I was editor of Al-Hikmah Awareness, and you were working for that printing company on Akoka Road, and it was always a pleasure to work with you as our lithographers and all of that for Al-Hikmah Awareness then. And it remains a pleasure for me to be able to tell you that I was so delighted that my family Islamic group, Ansaruddin, found it right to look for somebody of your caliber to take up the mantle after Sheikh Ali Arazim Alaya. May Allah strengthen you. Jazakumullah khair. Sheikh, all you said, I don't need to add anything. All you said, of course, is right. The only thing which you only want me to emphasize is all I'm going to add. It is wrong and it's not permitted to use sentiment of, and this is a very dangerous thing. And that is why Sheikh said it's a gray area where some ulama will prohibit it, that you cannot give gifts on the deathbed because you are now looking, Saeed, Abdulrazak, and Murzik. They didn't come to greet me in the hospital. They've not been taking care of me. It is only AbdulHakeem that has been here. Now I'm going to give AbdulHakeem 80% of my thing because all those ones are now bad children. It will be nullified and it's an invalid gift in my understanding. The rule of gifting remains, and it is because of that gray area that I understand it that some ulama say it's not allowed even to do gifts on the death, as we call it. Allah knows best. So the principle remains, like as you have said, Sheikh, that if it is gifts, the rule is different, but the rule is the rule of equity because it is haram. And if it is haram, it will be struck down. Allah knows best. So this is the only thing that I want to add. The other point you mentioned, I'm sorry, I just remembered on wasiya. Yes, it's really a challenge, right? To make it clear to us that the concept of wasiyah in Islam is not the idea we were being fed with as children of the Western notion of will. It's my will, I can do anything. In fact, it's the opposite, or it's a qualified one. The wasiyah gives you opportunity to do certain things, to do was, to call your children and remind them or your heirs that they are all going to face Allah and die one day, and they should fear Allah. That you use it also for an instrument. So you use it for a religious thing there to do was for them. You use it also to document what the assets are. You use it also to give and donate to non-heirs. And that is where it then makes a fundamental difference, like Sheikh pointed out, to our idea of will. And will me, no, there's no such thing. You cannot remove a hair from your will. It is only people who are not entitled that you can give gifts to in the will. But it doesn't change the fact that you are able to use it for that purpose. What is contentious is what Sheikh has said, the fact that we really need a lot of education. And Sheikh, you are better placed than I am. You have an audience that extends, you have an audience that extends to my late grandmother beyond the shores of Nigeria. So I think it's one of the things that we should use the Mimbar to educate upon, but it is a fundamental problem, I know. And it's like you said, when we are dealing with the ordinary people on the streets, not those on this forum, it can be a really tricky thing. But I don't think, this is my opinion, that we should run away from, unless of course we can find a better terminology, that we should run away from the idea that Islam also allows us to use this idea of the will in these ways. Allah knows best. Because the common law one, as lawyers on this forum know, is used for all of the other elements that the Sharia also recognizes, but except the idea that no, I can give whoever I want, whatever I want, is the one that is anathema to Sharia. Not surprisingly, because if it is not Sharia, it is not Sharia. Allah knows best.
Jazakumullah khairan to our lecturer as well as our Baba. Allah continue to enrich you in knowledge and goodness. There's a follow-up question to the last issue discussed, and it goes thus. This is a practical example from Malam Qasim. He said, my uncle had kidney issue before he died and needed a donor. All the kids resisted donation except his first daughter. On this, not as a compensation, he gave her 50% of his property. As Allah will want it, he died during the kidney transfer process. Is this acceptable in Islam?
No, it's my basic understanding. But there is a different issue here. And that different issue, and I invite Sheikh to also weigh in on this, please. That different issue is whether it is allowed to pay for a kidney as for medical reasons. My understanding, I stand to be corrected, is that if it will not harm the other person and they donate their kidney, or I don't know the Islamic view now, there isn't, if somebody else was giving them and they are going to pay that person and their own son gives them, I don't know, I don't understand it that they cannot pay them, but they are not allowed to do what they have done in terms of giving them, oh, you saved my life, I'm going to give you half of my inheritance. If they give them a gift, did you say, if they give them a gift while they are alive, they have to give gifts to the same gift in the same proportion to all of their children. This is where it's a very dangerous thing to conflate the power of willing and the power of gifting. While they are alive, they have to give equally. And when they are dead, they cannot. And that's why they try to subvert it. And you must not. This is exactly what we must, may Allah forgive, in my opinion, may Allah forgive our late brother. They must not do what that ayah or the hadith that I read was saying, that you are now depriving, even if they had lived, you are now depriving somebody of their share of the wealth. The intention is very important. I know they want to compensate, but it's also the case that that has to be done in the proper way. Allah knows best. If they were paying them a sum off for what they will have paid somebody else, that, Allahu Alam, unless there's a provision on paying for such a thing, my understanding is that is right. If it's $1 million, 1 million naira, 1,000 naira, that they will have gotten it for, and they pay their child for that, Allahu Alam, I don't have a problem with that in my limited understanding. But if they are gifting their property, they can't do that in that way. Allah knows best. If I'm wrong, I stand to be corrected, and I will learn better.
Jazakallah khairan. Can we take one question from those of the audience that raised up their hands? I will call on Malam.
Sorry. Just briefly. I'm sorry. I just want to bring these out, in clearer terms. Majority of the ulama have agreed that it is haram to, sell organ, from blood to other organs. It is halal. There is near consensus now that it is halal to donate, and donation that is without attachment. It is halal, you can donate, whether, while alive, if it is not going to occasion harm to the donor, or even at death, if it is going to be of benefit, to others who want to live. I know this is a very, very emotive issue that is not many people want to discuss it because they prefer something that is pro-life. But you see, in the case of a father who has a challenge and needs a transplant, and the children do not want to donate, one agrees to donate. For me, I think the gray area is, how did this agreement come about? Was it negotiated agreement? Is it based on the fact that, okay, if I do this, you're going to do this? Even if it is a gift, well, it is not as if a man or a woman, a person has unlimited rights to donate. There are rules guiding donation in situations like this. But the challenge here is that he is donating in such a manner that the heirs are the Alaikum salam. Alaikum salam wa rahmatullah. Alaikum salam. Okay, so that's just my my brief comment, but by and by, I think I agree with the lecturer that the situation is as he has stated. That's just my area of concern. Wallahu alam.
Jazakallah khairan. Okay. Madam Maruf Tijani, you may ask your question, please.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi.
I want to say a very big thank you to the lecturer and also our imam in the house. May Allah reward you abundantly. My own question is that now we're talking about giving gift to the heirs or siblings, and also making sure that we give them equally. What if I feel obliged to give somebody who is an outsider, somebody who has done something for me at a point in time, I want to give that person a gift? If I feel that, oh, I'm impressed with what this person has done to me, and I need to give that person a gift. So are we saying I cannot extend same to a son of mine or to a daughter of mine who has impressed me in one way or the other, has done something that is very, very significant to me? If I'm going to do that, I must also do to others. Is that what we're saying here?
Thank you very much for that. Definitely, you can give somebody who has impressed you a gift. Absolutely. But when it comes to your property and the rights of your heirs, you see, this is the thing. Even the person that's impressed you, there is a limit you can give in your will. In your will. That one, I assume you have no problem with. Sorry. Is somebody raising the point? So that, Bra Maruf, we are, like we said, even for someone that has impressed you, there is a limit to what you can give in your will. Now, in terms of when you are alive as a gift, your son has done something that has impressed you. When we are talking about gifts, I'm not talking about your first son as come first in class and you buy him a toy, you give him 5,000 naira, 1,000 naira, or something like that. But we are talking about substantial property. You buy a car for one. The same thing with your wives, for instance. This wife has impressed you so much. You're not allowed to buy a car for this one and not buy for the one that has not impressed you so much. In fact, you're not ordinarily allowed to buy a Jaguar for this one and then go and buy a Volkswagen Beetle for the other one. We know this. So there is really no confusion as per that. But it is even worse when you do that with children. You know, Allah subhanahu wa ta'ala, Allahu Akbar, He said, Allah ya'lamu man khalaqa wa huwa latiful khabir. Does He not know what He has created? He is the subtle that knows the finest details and is the fully informed about what He has created. When you have this, your son has done something so impressive for you and you decide that He has said, no, you don't eat like this, or you don't eat this. You don't drink this, or you don't use this. It's the same, my brother. I understand what you're saying, but Islam wants for justice, for equity, and for peace, all at the same time. And that is why it's always looking at things from not an emotive way, but from a very comprehensive and informed manner. There is nothing wrong in doing good to who has done good to you, including your children. But it is not in the way that, okay, I'm going to give him 20% of my property now. You are creating bad blood. Allah does not need our property. He's only wanting us to live in peace and harmony. Is the hikmah behind maqasid of Sharia, is the wisdom and reasoning behind it. So that is what we need to understand, and Allah knows best.
Jazakallah khairan. Let me take another question or set of questions from the chat box. I'll return to the raised hands. And I want to combine 2 or 3 questions together because they are very similar. And this is from Banjiba Bolagade. Can a convert child or spouse share from inheritance? Example is when a second wife and her children denounce Islam, even when the man is still alive. But the first wife and all our children remain steadfast. I hope you got that question, sir.
I got the first part, and
let me go by again. But I'll take 2 questions together. They are very similar.
Okay. Those are the 2 questions. Are those 2 questions?
It's just one. It's just from one person. But I have another one from another person that is similar to this. But I want to take them together.
Yes.
The first one says a combat child or spouse share from. Can a combat child or spouse share from inheritance? Example is when the second wife and her children denounce Islam.
Okay, I understand now.
When the man is still alive, but the first wife and all her children remain steadfast. Okay. That's question number 1.
Okay.
Question number 2 says, if a deceased person had clearly written that, that is, That's not exactly the, okay. So the second one is from Isaac Bakari. Can deceased, sorry, maybe we need to go, I think you should go ahead and answer that question first.
Okay.
I'm looking for the second one that is.
Second one. Okay.
Ahead, please.
Okay. Okay. So the first one, I got a bit confused because of the word convert. We have gotten used to maybe now because we're also using revert. One of the things, I don't know, I think it's in the second part. Yes, absolutely. Is part of the second part of my preparation that this question preempts, and rightly so. A non-Muslim loses their right to inheritance. So if you mean that a person has been a Muslim, under Sharia, they don't have, but there is a saving grace. This is one of the reasons why the wasiya is very useful and important. So you cannot, a non-Muslim child is automatically no longer a heir of the property of a Muslim, and vice versa. But because a Muslim has the right to give their property up to 1/3, they can, in a will, actually give a non-Muslim wife or child part of their property as part of the wasoya, part of the will. It is allowed to them, but it is not allowed for them to share of the estate, which is for the heirs. So if I just put that in context clearly, unless the husband has specifically made a will where they give something to their non-Muslim wife or children, that non-Muslim wife or child is automatically disinherited under Sharia. I don't know if that makes it clear. So they cannot share if they have not, if the husband dies without a will, or he dies with a will and he doesn't specify them as people he wants to give this or that, and whatever he must give must not come to up more than 1/3 of the property. Allah knows. Yeah. Have you found the other question?
Naam. Jazakallah khairan. Yeah, the second question, I think we have answered it. It's from Kazim, as the name written here. If a member of the here is a non-Muslim, can one make provision for them?
It's not a heir.
We're just like,
it's no longer a heir.
Exactly. So that is been.
If it's a heir, you can't make provisions for the heir. The fact that they are non-Muslim disentitles them from the title word heir. This is part of what Sheikh Ahmad was saying about the terminology we get in our head. Simply because somebody is your child does not automatically make them the heir unless they meet certain conditions. One of which will be that they are Muslim. That they are your wife, they have to be. We'll talk about this if Allah.
Now, another question.
In the next lecture.
Now, Jazakallah khairan. Another question says, as a follow-up to one of the questions earlier answered, if a deceased person has had clearly written that his estate should be administered according to Sharia principles, but one of the children who could naturally be here, but had left the fold of Islam, the individual who has now abandoned Islam insists that the estate should be administered by the custom or common law. What should others do?
They take the matter, they try and resolve the matter on a family level by mediation, which of course will mean that that child will not be able to take of the property. So it's likely that it will go into litigation, to be honest, really. And under the law, all that will need to be established is that that will is valid and that person lived their lives as a Muslim. And once that is the case, it's like any other will. You can disinherit a child under the common law assessment, which they can look at it. So it's not an issue. You have to go to court, sadly.
Now, Jazakallah khairan. This is from Fash. 2 questions from Fash. It says, can you share your will while you are still alive? Is it Islamic? That's question number 1. Question number 2 is, for those who have wrongly shared their inheritance in ignorance or belittle the element of Sharia imputes, then can the inheritance be shared or can it be reshared? Who are the experts that can assist if valuation is involved?
The last 2 parts, as a person, as an individual, I don't have answers as to specific individuals, but I'm sure within the fold of H&H, you'll be able to get them. If the person wants to mention names, I work in a jurisdiction where we are not allowed to mention names like that, but I have mentioned 1 or 2 names here earlier, and I will advise them to get in touch with those people. So at least one of them has spoken here today. They will be able to direct them. But specifically, you go to a credible Islamic organization like the Ansaruddin, you have the shuyukh there. They would, if you are meaning to, they will be able to assist. And they will then also probably call on, if there are complications of mathematical calculations, call on people who have mathematical knowledge to be part of it. When it comes to ilm al-faraid, it's not just about it. You have to have people who are good in maths, statistics, whatever. You have people who know the ulumuddin and faraid, like Sheikh Ahmad, Sheikh Harun Thani, and all of them. I'm not one of the shuyukh. Me, I am a student. So that is the answer to that. But yes. If you want to do it in the proper way, you'll be helping the person. And it is actually excellent. And you should try and do it. And if you can do that with agreement of all of the parties, this will be excellent. You then write you write a memorandum that will be legal document saying we prefer to have this shared like this, and it will abide in law. There are lawyers who then also will join to make sure that this can hold as a legal binding agreement. Definitely, this is the best to do. May Allah make it easy.
Now, Jazakallah khairan. May I allow one of our directors, who is also an audience here, to make some contribution? By Sanasif Salah, please, can you make your contributions? By Sanasif Salah.
Yes, Assalamu alaikum, can you hear me? Okay, I just want to add 1 or 2 points. The first is that if one is advisable, if one has that inclination that there will be problems after his demise, to do a will specifying that his estate be shared in accordance with Islamic law. Then secondly, a person who is guilty of the death of the testator is not entitled to inherit in Islam, just like an apostate. Assalamu alaikum.
Please go ahead. Wa alaikum salam wa rahmatullahi wa barakatuh. Okay, can I also, okay, there is one sister Amina Ogunfowora. Can you make your contribution, please? Very swiftly, please.
Assalamu alaikum.
Wa alaikum salam.
Wa alaikum salam. Amina Ogunfowora.
Okay.
Amina Ogunfowora.
Naam, assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Yeah, thank you so much, sir. Jazakallah khairan. My question actually, because I joined late and I want to ask, my mom used to be a Christian but then she reverted. She's now a Muslim, Bismillah. But her parents were Christians before they died, and then the mom left behind the house for her. Does she have a right to still collect from that rent? I need to know, because she's trying to sell off the house. No, not sell off actually. She wants to she wants the children, with the children, to try and buy the house, and then so that it will still remain like an ancestral home, kind of. So what advice do I give her, sir?
For clarity, sister, this is a very apt question. When she inherited the property, was she a Christian?
No. She was a Muslim, but I'm sure she didn't understand that what Islam entails, what Islamic perspective concerning that, as well as the kids too. It's been a while. No, she was already a Muslim. She's already a Muslim.
When her mom died.
Sir? Yes. My died 20 years ago. So she was already a Muslim at that time.
Okay. And she inherited it not from a will. She inherited it in tested, i.e., her mom did not make a will. She just died, and all her children, and your mom being one of them.
She inherited it because they are just two. She has an elder sister who is also a Christian, but she is still a Christian.
I understand.
Only my mom converted to Islam.
I understand. Yeah. I will leave the question to Sheikh Ahmad.
It's really a very tough one. I think there have been similar cases in the past, similar, I said, and there is an instance that I remember. The principle that was used was al-Islam yazid wala yankus. Islam, increases and enhances your share. It doesn't decrease it. But I think on the face of it, because one of the grants were disallowing mutual inheritance is the difference in religion. Now that the daughter became a Muslim, and the mother, remained a Christian, ordinarily on the face of it, there is no mutual right of inheritance. She cannot inherit from her mother, and her mother could not also inherit from her